to Northland or to New Zealand is the practical changes that are required to the Resource Management Act so we can have more houses, so we can have more jobs, so we can have less bureaucracy and that we can have a stronger economy.
I'm calling Eugenie Sage.
Mr. Chair, thank you very much. Mr. Chair, government members aren't falling over themselves to take calls on this bill. They seem to be leaving it to the minister to defend this shambles of a piece of legislation. They're too scared, Mr. Honourable Winston Peters says. I agree. Mr. Chair, we have in this bill, it's been a shambolic process. It's been pushed through Select Committee. Negotiations have occurred with the Māori Party completely outside the Select Committee process. There hasn't been substantive debate within the Select Committee. We are not going to see a bill that is agreed to across the Parliament, the way the Resource Management Bill was when it was first introduced and passed in 1991. It's got a slew of supplementary order papers on the table. It shows that this minister has failed to get agreement around major changes to our primary environmental law. And there's been a lot of hot air from the minister in defending the bill. He says we need it to keep stock out of streams. Well, it's taken 9 years almost to do that when there are national environmental standards and a mechanism in the RMA when if he had been serious and the government had been serious about protecting rivers from stock incursion, they could have put out a national environmental standard and ensured some consistency across the country in the rules that regional councils have developed. This is going to be too little too late because a lot of councils have already developed their rules around stock exclusion. The minister is saying that the bill is needed to reduce bureaucracy, but what it's doing is reducing democracy and the ability of the public to participate in their plan making. The minister extolled the plan making processes in Christchurch and Auckland. He obviously hasn't talked to residents in Christchurch because that district plan review process, which yes did happen in a very truncated way, has meant that only those who've had access to lawyers and experts like planners have really been able to participate. Lay people have been shut out. And that's what provisions in this bill, in terms of reducing the ability for lay people to participate, having a bespoke planning process, the streamlined planning process that the bill introduces, are all about. Reducing the ability of all of the community to engage in the plans that their councils develop and instead limiting that to development interests and those who've got access to money. The minister claims that we need the bill because there's duplication between the hazardous substances provisions under HASNO and the RMA. Yet he acknowledges that there is a case before the courts which will clarify this relationship. So why doesn't the government trust the courts to make that clear? Mr. Chair, the bill was commented on and the Act was commented on earlier this week by a Hawke's Bay barrister, Martin Williams, who said that the Act has been amended so many times by successive governments that it has become incoherent. And the Act at the moment was initially 383 pages. It's now nearly 700 pages long. This is a 248-page bill. It is going to make the Act even more complex, even more difficult to administer. It is going to reduce the ability of residents and communities to understand what the Act is all about and how councils apply it. It means that only those who've got the ability to pay lawyers to interpret it for them are going to be able to participate. The bill is also unnecessary because the government and the Productivity Commission, with its report recently on urban planning, and the government having commissioned the Ministry for the Environment to undertake blue skies thinking on the RMA, potentially all this becomes redundant in a couple of years. So why has the minister put the public and all of the 700-odd submitters who made quite detailed critiques of a lot of the legislation to all of this trouble to make it more complicated when blue skies thinking is underway about whether the RMA needs to be dismissed entirely and replaced with new legislation? And what we had from the minister in his first speech was quite a lot of hot air around this bill. He claimed that the issue around natural hazards was important, and he is right there in terms of section 6, and in my calls on the bill I'm going to go through the bill. So starting at the start, Clause 5 amends Part 2 of the Act to insert the management of significant risks from natural hazards as a new matter of national importance. Mr Chair. Thank you, Mr Chair. And the Green Party agrees with that. But this is yet another example of the government being all show and no substance, because the majority of submitters agreed with that becoming a matter of national importance. And certainly in Christchurch, there were large areas that were prone to liquefaction during the earthquakes when they had been zoned for subdivision, despite the fact that the Regional Council had identified these areas as being prone to liquefaction. That wasn't a matter that was taken into account. So it's obvious that we need this as a matter of national importance. But it's not enough just to put it in the matters of national importance in Part 2, because the bill goes and creates very permissive provisions around subdivision. And the Geological and Nuclear Sciences, our CRI, Crown Research Institute, which has all of this expertise on natural hazards, made it quite clear in its submission that there also needed to be changes to Section 106 and 220 of the Principal Act. And that's because it's those submissions which specify the circumstances in which a consent authority can refuse a subdivision consent and the conditions around which a subdivision consent may be granted. And at the moment, Section 106 only allows a consent authority to refuse or conditionally approve a subdivision consent in quite limited circumstances around specific hazards. And they are whether there's going to be material damage to the land or structures from erosion, from falling debris, subsidence, slippage, or inundation. It doesn't talk about seismic hazards. It doesn't talk about rising water tables. It doesn't talk about sea level rise. So if the government was genuinely serious about recognising natural hazards in planning instruments, then it would have done what the regulatory impact statement suggested and gone ahead with the amendments that were originally proposed to those two sections to allow councils to actually put conditions on subdivisions and those consents. But no, this bill is going to make subdivisions permitted once the land has been zoned residential. So once again, it's an example of all show. We put something in Section 6, but no substance. And I guess the only thing we have to be thankful for in this bill, Mr Chair, is the fact that it was widespread public opposition from environmental organisations, other community organisations and others that stopped the Minister from taking an axe to Sections 6 and 7 to completely undermining all the bottom lines in Part 2, as his predecessor, the Honourable Amy Adams, had proposed. And it was that opposition that had the government running scared on doing that. But nevertheless, there has been a fundamental broken promise on this bill, because the Prime Minister at the last election promised that there would be an exposure draft. He gave people the impression that there might be some genuine consultation on the bill before it was introduced. That didn't happen, and it's been a shambolic process through Select Committee to get to the stage that we're at the moment. The other issue with the natural hazards is that there is no definition of significant, what constitutes a significant risk from natural hazards. The Minister has promised a national policy statement. There is still no national policy statement on Indigenous biodiversity, despite the fact that that has been a matter of national importance under Section 6C from the time the Act was first passed in 1991. It's been promised by successive governments and hasn't been developed and implemented. So I have no confidence that one on natural hazards will be developed anytime soon. And our major concern is again around these streamlined planning provisions, the bespoke planning process, that will cut the community out. And when you're dealing with natural hazards, when you're dealing with how communities assess risk, and what action should be taken as a result of that assessment of risk. You need everybody involved. But the planning processes that the Minister's going through with the national planning templates, now become national planning standards, and the streamlined process mean that there's much less likelihood that people will be genuinely involved. And Mr Chair, I'll take a number of other calls to highlight the Green Party's opposition to many other sections of the clauses in this bill.
I call Grant Robertson.
Thank you very much, Mr Chair. The first